want this job.
Well, thank you for your integrity, and I won't belabor it because I do know that there are some other people that must testify, and I believe that we have a deadline to...
Well, and now I have a message from Representative Hurd. He wants to come down here and be heard on the issue of the similarity in appearance between you and him. Chairman Knox.
Thank you, Chairman.
Yes, sir.
Back on county. If we pass this bill into law, and our experience then becomes that we're not really getting the results that we had hoped for. In other words, we're not correcting the problem with the aberrant juror, which I think is what we're attempting to do here, or the nullification of other votes, nullification of the majority. Follow me?
Yes, sir.
I know it's a long question. Would you then think that we need to look at whether or not we need to reduce the number further, say to 8 or 7 instead of 9?
I would not. I would not. I think 9-3 is a very good number, and I think if you have more than 3 jurors that you want to call aberrant jurors, then there's another issue there involved, and that would be the jury would be speaking in that case. I would not be in favor of that.
Further questions of Mr. Kelly? Vice Chairman Munford.
Have you ever known a jury to go back and forth on where the vote actually changes? At one point the vote's going one way and it changes up or down?
Death penalty case.
Yeah.
Well,
Are you the penalty or in the Senate?
Case, really.
I've had that happen.
I mean, you believe that happens in a jury room sometimes. At one point it might be 6-5, then it might go to 7-5 and wind up at 4.
I've never seen it in the 20 years in a sentencing phase of a jury, but I have seen it in a guilt innocence phase.
Right. If we adopt this into law and the jury foreman comes out and says, well, Judge, we're currently 9-3. And the vote before that, they were actually 8-4. And that vote was taken 2 minutes before the last vote. Could that happen?
I think it could happen. I think it's whatever jury reaches as their final verdict. If it's like I guess the game shows, that's your final answer, and that's what the judge has to ask those jurors when he brings them back in.
But that's not really the procedure, is it?
Well, I think it would be once they got to the point where that judge were at 9-3, and that's where we're holding, and he'd bring them in, and that's when I believe the 1-2-3 that we talked about earlier would take place, and the judge would have to ask them, is that your verdict? Was it? And we asked about that question of somebody later impeaching. I think it's why it would be important for a judge to follow the normal course of practice, and that would be to ask, was that your verdict? Yes. Was that the number in the jury room? Yes. And was it freely and voluntarily given? Is that your understanding? That kind of a thing.
Under our current law, there is no standard for determining what might mitigate a death penalty. Is that correct?
That's correct.
And under our current law, the mitigation can be found for any reason.
For any reason.
I think you would agree with District Attorney Porter. Defendant had red hair.
Whatever reason.
Whatever reason. All right, thank you.
Thank you.
Further questions of Mr. Kelly? Thank you, Mr. Kelly.
Thank you.
Mr. Whip. Excuse me. Come around and sit down if you'd like. Very. Questions of the committee for Mr. McDade? Any questions? Thank you, Mr. McDade. Mr. Whip? Okay. Thank you very much. If I might inform those that are here that have an interest in this bill, there are many people who have signed up. I spoke over the lunch break with Mr. Martin to see if, for the benefit of the committee, we could organize the presentations of the opponents. And I think we have come up with a method of doing that. Jack, I want to recognize you and Sandy to begin. Is Sandy here? Okay. And just for readiness purposes, Chris Adams and Jerry Word will be on deck.
Thank you, Mr. Chairman and members of the committee. I'm Jack Martin. This is Sandra Michaels. We represent the Georgia Association of Criminal Defense Lawyers. I want to start out with, and I apologize to some extent because we presented yesterday, and there's a number of members of the committee who heard from us yesterday, and I'm going to repeat some of the things we said yesterday just because there are new people here. But I think some of them are worth repeating. Start out with a principle that we all know in the law, which is hard cases make bad law. And that principle we all learned is that when we try to fix a particular problem in a particular case, and we try to jiggle with the law, fiddle with the law to try to fix that one case, that what happens is there are unintended consequences which create a tremendous problem throughout the entire system. That's one principle I think the committee needs to keep in mind, because this is a major change in the death penalty law and is being based primarily upon some hard cases. Second principle, which is the principle that's been announced by the United States Supreme Court over and over, and it just makes sense, which is the principle that death is different. When we're talking about the most severe penalty that can be imposed in the law, the only time that we as citizens say we are going to take another citizen's life, when we go that far, we need to be very modest about our ability to sort that out. And we need to be very careful that we have the best protections possible in the law in order to make sure we are doing the right thing. Because face it, death is mysterious. It is an imponderable. All of us have thought about death at times in our lives. It is a mystery. And when we're talking about taking somebody's life, it behooves us to be very careful. I've said before, it's the one time that we presume to act like God. And when we presume to act like God, we should be careful and act like God as best we can. I think it bears repeating what the history of the Georgia death penalty statute is. The system we got didn't come here by accident. The system we got here isn't something that we can fiddle with every year. What happened is in 1972 there was a famous case, Furman versus Georgia, which held that the Georgia death penalty was unconstitutional. And the Supreme Court basically said that all death penalty procedures in the United States were unconstitutional. And after that, various different politicians, including politicians in Georgia, and then Governor Jimmy Carter, said, let's see if we can devise a scheme in Georgia that will allow for the imposition of the death penalty that will satisfy the concerns of the United States Supreme Court in Furman. And what they did is he asked three of the best lawyers that ever served in this legislature, Denmark Groover, Elliott Levitas, Robin Harris, who were on this committee, to sit down and come up with a procedure that made sense, that would satisfy the concerns of the Supreme Court. And they did. They came up with the death penalty statute that is the one on the books today, that hasn't been changed except in one small respect since that time. And what they said is, what we'll do is, the concern is that we make sure that the death penalty is reserved for the worst of the worst. What we'll do is we'll say, first of all, it won't apply to all murders. It will only apply to certain murders where the jury finds beyond a reasonable doubt that there are certain aggravating circumstances, such as in the commission of a capital felony. That's the one most typically used. Such as the defendant has a prior capital conviction, such that it's the death of a police officer in the line of duty. Limited array of potential murders for the death penalty. The second thing we say is that the defendant has the right to present to the jury anything and everything which may be mitigating about sentence. We often see the horrible pictures of the crime. But, ladies and gentlemen, I tell you, having done this work, there's usually another side of the story. Not an excuse, not a justification. But there's mental illness, there is terrible abuse, there's things that mitigate sentence. Not all cases. It would cause you to impose a sentence, a terrible punishment, life without parole, as opposed to death. Nobody's going to go unpunished. So the system devised by those three lawyers says the jury ought to be able to hear anything and everything about the defendant in order to make that wisest. The wisest decision will be if a jury is the best informed. The next thing they said, that verdict, all the verdicts, have to be unanimous. That's what these three lawyers came up with. Because we want to limit this to the fewest cases possible, the worst of the worst. We want to make sure that it's not just a majority that says death is appropriate. It's a consensus of the community. And that was important not only because we wanted to limit it to the fewest cases, but because we wanted there to be credibility to the verdict. We wanted there to be no sense that the verdict, a legitimate verdict, no one could complain, well, we've left out a certain part of the community in making this decision. There is a group in the community that came into the jury who sees this as a life sentence or a life without parole sentence, and they are not going to be ignored. We want legitimacy, we want unanimity, we want consensus. And the last thing those lawyers said is we want this all to be reviewed by the United States Supreme Court. And we want, by the Georgia Supreme Court. And every death penalty sentence has to be reviewed by the Georgia Supreme Court, automatic appeal, and has to be reviewed for proportionality. In other words, that we're not imposing a death penalty on these cases and not these cases. Those were the four basic principles of that system. Now, other states were doing the same thing. North Carolina was trying to devise a system. In North Carolina, they came up with a different system. And in that system, they said, well, if you commit certain murders, you automatically get the death penalty. Arizona was coming up with a different system, which basically allowed the judge to do the sentencing basically in that system as it was originally proposed. It's changed over the years. And Alabama and Florida came up with a different system, which was a system whereby the jury would make a recommendation, but the judge would make the ultimate sentence. And those were the four basic plans that came out. All of them went to the United States Supreme Court. Supreme Court in Woodson versus North Carolina said, North Carolina system, it doesn't play. It doesn't satisfy Eighth Amendment because it doesn't allow the jury to take into account the myriad of facets of human frailty, is the word they use, that may be a reason to impose a sentence other than death. The Arizona system was for a while upheld by the Supreme Court in Walton versus Arizona, but in Ring versus Arizona, the United States Supreme Court said, no, that wasn't a good idea either. They said, well, the problem is we're not having a finding by the jury of those aggravating circumstances. And that violated the principle that Justice Scalia, the most conservative judge on the Supreme Court, the most strict constructionist judge on the Supreme Court, these are strict constructionist judges who are throwing out these death penalties, said that violates the Bill of Rights because you have a right to a jury determination of any aggravating circumstance. So what happened was the Georgia system went up. In the case, Tony Gregg was the defendant, an awful murder case. And Tony Gregg had gotten the death penalty. And Tony Gregg, and in Gregg versus Georgia, 1976 case, a majority of the Supreme Court upheld the Georgia system that had been devised by lawyers sitting in this very room. And they said, this system works. This will satisfy any constitutional concerns. And that system has remained in place for more than 30 years and has been repeatedly upheld. The only change we've really made in it was a small change, which was that we will allow the jury the option of life without parole. But the aggravating circumstances have stayed the same. The jury unanimity has stayed the same. The necessity of the jury finding aggravating circumstances beyond reasonable doubt has stayed the same. The review by the Georgia Supreme Court for proportionality has stayed the same. And we haven't tinkered with it one whit. because, quite frankly, ladies and gentlemen, in Georgia, there's been some problems with representation. There have been problems with jury selection. But the basic statutory system has worked. And this is the first time that, because of a few bad cases, we've decided to tinker with a system that has been upheld by the Supreme Court for 30 years. And it also raises questions about the policy of making that change, because the system has worked. When the federal government decided to create a federal death penalty in the 90s under President Clinton's administration, they didn't look to the North Carolina system or the Alabama system or the Texas system or the Arizona system. They looked to the Georgia system. And the federal death penalty is essentially designed after the Georgia system. Unanimous jury verdicts, unanimity as to sentence, the right to present anything in mitigation. So what you're trying to do in this case, albeit for maybe one or two small bad cases, is tinker with a system that has been working. Let me talk briefly about Alabama and Florida. In Alabama and Florida, the system there is not what's being proposed here. The system there is that the jury hears the evidence, and the jury makes a recommendation, and then the judge is the final decision maker. And there are standards of review based upon the jury's verdict, whether the judge came to a different verdict of the jury or came for a similar verdict of the jury. And that system has been challenged. One of the reasons it got challenged early on and was almost brought down was the Hickok case, which, because under the statute in that case, the jury and the judge could only consider certain statutory mitigating factors that were listed by the legislature. The Supreme Court said that's unconstitutional. Look to the Georgia system. The Georgia system allows anything to be presented in mitigation. We throw out the Alabama and the Florida system on that basis. There's been similar attacks in other states on similar types of procedures where they had to define the statutory aggravating circumstances, and when they passed the federal system, they made clear that the jury can consider anything in mitigation. The Florida and Alabama systems are today under attack because of the problems raised by the Ring case. Now, you will hear shortly from Professor Emanuel, who believes that this system that you are trying to place in, trying to amend the Georgia system will, no one can say for certain what the Supreme Court is going to do, but in her learned opinion, it's going to be found unconstitutional. I will say that it will definitely is a close question, because footnote 4 of the Ring case itself leaves open this question of whether you have to have unanimity on the ultimate verdict in a jury system. I wanted to mention all those things because it's no secret I'm an opponent of the death penalty. But if we're going to have a death penalty, my experience is the Georgia system, if you properly fund it, is the best system for doing it fairly, for doing it constitutionally, for doing it in a fashion that reserves the ultimate penalty truly for the worst of the worst. It's not a perfect system, but it's as perfect as we're going to get. Let me point out a few problems with and issues that will be raised. There's a famous case called Caldwell versus Mississippi. And in Caldwell versus Mississippi, the Supreme Court held that if you told the jury that your sentence was just going to be a recommendation and that the judge will ultimately decide the case, the jury has lost responsibility for its verdict, and that is unconstitutional because, in fact, even though in Georgia we say it's a jury recommendation, in fact the judge has to impose the sentence that the jury recommends. If we have a system in which jurors know we only need 9, and we just have 9, and the judge will then decide. We then have a potential Caldwell versus Mississippi problem. That's a problem we don't need. That's a problem this legislature doesn't need to venture into. We have a potential Caldwell versus Mississippi problem. we have this practical problem. And all of us talk to jurors after these cases, and we hear about, gosh, the types of deliberation that goes on in these cases is heartfelt. It is as personal. It goes to the very heart of your existence. And jurors deliberate. If we tell the jury that you only need 9, and there are 3 out there, perhaps they're minority jurors, who disagree, who see something in the defendant who in their experience they can connect with that the other jurors don't, the 9 can just ignore the 3. They have no need to engage them. There is no need to engage in deliberations. There is no incentive to come to a consensus and a unanimous verdict. I've already mentioned the notion of legitimacy. Generally speaking, in this state, when a death verdict comes down and we know that it was a unanimous verdict of 12 jurors, there's a certain legitimacy that attaches to it. If we start having people executed when there were 3 reasoned moral decisions against it on that jury, and whether it's true or not, there is the worry that the judge who imposed the sentence may have been concerned a little bit in his or her mind about how her sentence might be perceived in the community, that there might be a advertisement placed against her next election, and that may have had something to do with the decision. I don't know, even if it was unconscious. That defeats the legitimacy of that death penalty. And we all want, when someone is strapped to a gurney and poisoned, we want to feel that that process was totally legitimate. And when we go to 9-3, that level of legitimacy is diminished that much more. There are other questions about this judge situation. Should the judge be death qualified? By that, is the attorney entitled to question the judge before the trial to whether or not that judge can actually consider a sentence of life without parole or life in this particular type of case, or would automatically always impose a death sentence? Is there prejudice in the judge that needs to be examined on this issue? Finally, and I wanted to mention, maybe next to finally, the state constitution, and I'll pass this out. It is. I'm sorry I didn't push it far enough. The state constitution has been revised a number of times, but every time it's been revised, it says that the right to a jury trial shall be inviolate. And the most recent constitution talks about a 12-person jury being an inviolate right of the defendant. While it's true that neither the United States or federal constitutions say that a unanimous jury is that word does not appear there, paragraph 28 of Article 1, Section 1 says this. This is the present Constitution. The enumeration of rights herein contained as a part of this Constitution shall not be construed to deny to the people any inherent rights which they may have hitherto enjoyed. What that says is, just because it doesn't say you have a unanimous right to a jury, the jury right is unanimous, doesn't mean that that right, if it is a right that's an inherent right, enjoyed, which it was at the time of the Georgia Constitution, this most recent Constitution was passed, has been diminished to any extent. Knowing how litigation goes, I'm not going to come and honestly tell this group that I can tell you that that is a winning argument in the Georgia Supreme Court or not. But it is an important argument, because I know in Georgia we have always had unanimous juries, even in divorce cases, even in condemnation of property cases, where there's a question of the value of the condemnation. Surely we need to have a unanimous jury when we're talking about the condemnation of a human life. Those are my general thoughts. I caution. Justice O'Connor, one of the best justices we ever had in the Supreme Court, sort of crystallized what happens when a jury makes a decision in a death penalty case. And she says a death penalty decision should be a reasoned, moral response to the defendant's character, background, and crime. Reasoned and moral. And the juror who was in the Harris case came in here yesterday, and hopefully he will be here today, said, my reasoned response was, I don't believe that you should impose a death penalty when there hasn't been premeditation. Under Georgia law, we know that premeditation can occur in an instant as far as guiltiness, as far as guilt. But that is a reasoned, moral judgment from a CEO of an engineering firm who looked at it analytically and came up with that decision. And indeed, I think it was mentioned that today by some of the prosecutors that they don't really challenge that. That was valid. So why, in a case in which we now have a valid, reasoned, moral judgment for that person, in that particular case, which you may disagree with or I may disagree with, throw out more than 30 years of law, which is settled in this state, which has created a death penalty system that statutorily works, just because we want to make it easier to get the death penalty in a few cases. I really believe this is a bad mistake both under the law and in policy. And I'm sorry for being so preachy about it, but it's very important to me.
Thank you very much, Mr. Martin. Cindy, did you want to add something now?
No, I was going to raise funding issues, but I think other folks can raise those.
Okay.
Thank you.
Let me ask one first. And Jack, forgive me for not remembering how long you've been around this Capitol following issues like this.
It's been about 20 years, maybe as long as you've been here.
Okay. Probably too long. You mentioned that Georgia had not changed its death penalty statute except in a minor respect in about 30 years.
Right.
But don't I recall a bill back in the mid-90s, I think it passed the Senate, that approved of non-unanimous verdicts in death penalty cases, and I don't remember what happened in the House.
Yes, I can't give you the exact year, but during the administration of Joe Frank Harris, actually a bill passed both houses.
Okay, now that was sponsored by former Governor Barnes, as I recall.
No, a later version was sponsored by.
Okay.
Some people were asking me some people we needed to get here today, and I figured he was not one of the ones we needed to get here today. But Bob Barr was happy to come, but couldn't make it because he's out of the country. Politics make. Go ahead. Yes, Joe Frank Harris, Governor Joe Frank Harris, vetoed that. With a very profound veto statement, which he didn't just veto, he said why. And he said, we should limit the death penalty to the worst of the worst. And I don't want to make it easier to get the death penalty. And Joe Frank Harris was no flaming liberal or no opponent of the death penalty. So that's the history in Georgia. Former Governor Barnes did sponsor a bill like that one time, and it didn't pass.
But the Senate did pass one, and I'm thinking it was like in the 95, 96 time frame.
That's correct.
That went to, I think, 11-1 or 10-2. Do you remember?
My recollection, it was 10-2.
Okay.
And all of these bills
in response to a case in Cobb County, as I remember.
The Freeman case. And I do remember that case. The holdout was an African American juror. The defendant was African American. The sole African American on the jury was the holdout. And that was a circumstance that many of us thought raised the credibility questions. And Governor Barnes, being from Cobb County, was a sponsor of that bill. But it did not. My recollection is more clear now as I think about it. House Special Judiciary did not pass that out.
Okay. So this issue is not a stranger to this body.
No.
Okay. All right, Vice Chairman Mumford and then Representative Collins.
Warren, I've got a question. I'm not sure that you can answer it. You're probably as good a person to ask as anybody. I'm looking at your handout here.
All right.
I want you to go down to the 1798 Constitution. It says, freedom of the press and trial by jury as heretofore used in this state shall remain inviolate. You know what they meant by as heretofore used in this state when they wrote that in 1798?
Well, I do have another handout which I was scared to hand out, but it is Blackstone on jury unanimity, which I will hand out now that you've answered the question, but it was common law.
That's what I thought it was called.
And Blackstone on common law has, as you can see in the number of sites, and they're hard to read because what we now call S's or F's in that, but Blackstone clearly said that common law, going back to the Magna Carta, jury verdicts had to be unanimous. It was a protection against abuse by the crown. Now, the jury system has always been a protection against abuse by the executive.
So Blackstone said this would have been the law in our young state.
Right.
That for tender is the law of England of the lives of the subjects, that no man can be convicted at the foot of the king of any capital offense, unless by the unanimous voice of 24 of his equals and neighbors, that is, by 12 at least of the grand jury, which we now require 16 at least, in the first place assenting to the accusation, and afterwards by the whole of the petit jury of 12 more, finding him guilty upon his trial. Is that petit or petty?
I think it's petted, but I don't know. Petted. I've always said
I need
petted.
somebody who speaks French.
Petit.
Well, you know, we also say nolo contendere and voir dire and lots of things.
We make it up as we go along sometimes.
Voir dire is one that's pronounced different ways above and below the net line. Right. The Georgia still, you know, when we revised the criminal code, we did away with common law crimes in the 60s. And that was the first major revision of the criminal code in Georgia. But all of the common law rights have always remained, including the common law right to an indictment in a capital case. I won't take Dean Emanuel's thunder, but the Ring case and all the cases, there's Supreme Court cases that say that a non-unanimous verdict is okay in a non-capital case. But the Supreme Court cases have always added that phrase, non-capital. You can have a non-unanimous verdict in certain felony cases, but not in a capital case.
May I follow up?
Sure.
As an aside, Georgia, in fact, had the first written code in the United States, did it not? That was published, written code. Are you aware of that fact?
You know, I wish my brother was here because he could tell you precisely the answer to that question. He's an expert in that area, but I think you're right.
I think it was 1853. It was published in Athens, Georgia.
Right.
So before that, we relied on the common law.
Right.
Thank you.
Representative Collins.
Thank you. I have read the Ring decision. I currently am reading the Ring decision. I pulled it up after you stated footnote 4.
I think I got the right footnote. Hope I did.
Well, I'm not sure we have. That's why I'm asking for clarification.
This was the issue in Ring. The Ring issue was whether the jury had to find the aggravating circumstances. The Supreme Court has held that in order to narrow the cases of murders, narrow the number of murders that are eligible for the death penalty, you have to find certain aggravating circumstances, and Georgia has that. Now, in that footnote, they are talking about, well, we're not going to reach the question of whether jury unanimity has to be with regards to the ultimate decision of death or any other subsidiary decisions. And indeed, they're saying we're not reaching those issues as if those might not be as hard. Excuse me, we might decide those the other way. As I read that, if I got the right one, my recollection, I had my notes here earlier.
You may be extrapolating a little more than the way I read. There's far learned more minds in the room. I'm sure I'll get the answer here in just a second. But I was trying to follow because you were dealing with a constitutional argument which has been raised. Specter's been raised.
If you look in the middle, excuse me, I didn't mean to interrupt you. Go ahead. If you look in the middle of that, after the citation to Apprendi, It says, nor does he argue that the Sixth Amendment required the jury to make the ultimate determination whether to impose a death penalty. It cites the Prophet versus Florida case, which left that issue open in a plurality decision. So all I'm saying is that Ring clearly doesn't decide that issue. Now, they may decide it, differently than they may decide that it's constitutional, but it relieves it open. It's the only reason I mentioned that.
Nor does he argue that the Sixth Amendment requires the jury to make the ultimate determination. Okay, so he's not arguing that the jury be required to sentence him to death.
Right. So what I'm saying is Ring never reaches that issue, but in the footnote leaves that Sixth Amendment issue open.
I'll buy your argument.
Okay.
I agree with what you're trying to say. I'm not sure it actually says that. I appreciate it. I'll work on it.
Okay. Who was next? Chairman Knox?
Yeah.
Let me see what your response is, because I've asked the other witnesses the same thing I'm going to ask you. What is your response to the idea that a single juror or even 3 jurors should not be allowed to nullify or validate the votes of the majority on juries?
How you phrase it, I guess words make a difference. What I say is that what you're looking for in this one area is consensus, unanimity. And we require that in jury verdicts in all different types of cases right now. And just because a holdout juror says, I'm not going to be unanimous, we don't mean everybody else's vote has been ignored. We say the remedy in that situation, in most cases, is a mistrial. We'll start over again. So you're not, especially when jurors are told this in death penalty cases, that you're not there to take a majority vote. You're there for each and every one of you to individually decide whether death is the appropriate sentence. So that single person or 2 or 3 people who say, I don't see death being this case, they're not nullifying the other verdicts. They're just saying, we don't agree that this is unanimous. Therefore, we don't have the consensus that we would require in this one area of the law with regard to jury sentencing. I guess when this body votes sometime later today, one side's going to win, the other side's going to lose. Those votes are not nullified. They just didn't have what was statutorily required to prevail today. In a death penalty situation, since we require 12, since it's such a unique situation, since it is such an imponderable decision, we say we require consensus and unanimity in this one area of the law.
Mr. Chairman, if I can do a follow-up.
Yes, go ahead.
I'm not trying to argue with you, I'm just trying to understand, because this bothers this particular question, or this idea, because I think it's a legitimate concern.
Sure.
I'm not sure that a unanimous verdict is the same thing as a consensus verdict. A consensus verdict could be a majority. That would be the consensus of that jury, is the majority of the people think this is what should happen. I think that's a consensus. So I'm not sure that I agree with you that that's what we're looking for from a jury when we have, if our goal or objective is to have a unanimous decision. That's not a consensus. Or maybe it is. It's an absolute consensus, I suppose. But so is a less than unanimous is a consensus verdict. So you want.
Well, I don't want to, Representative Knox, I don't want to quibble over words. When I use the word consensus in this situation, like often this body do matters by consent or by everybody agrees. There's no objection on it. I mean, we all agree that we're going to recess or what we're going to do. And that's what I mean by consensus, is that it is a decision by the group in which all are willing to sign on. And in my experience, I've tried a number of death penalty cases. I have never had a jury not reach a consensus, one way or the other. Unanimous, one way or the other. I've won them and I've lost them. And so this is not, And none of those cases was I playing for one juror. I was playing to win the case. I mean, there are consequences if you don't get a verdict. If you appeal, they can retry you again if you get a new trial. So there is a difference between a verdict and in this situation. There are all sorts of differences. But my experience has not been the holdout juror. My experience is either they go all the way one way or all the way the other way. And that happens most of these cases. Not all, but vast majority.
I asked this, if I may, Mr. Chairman.
Sure.
I asked this of some of the other witnesses as well. Right now, I think the argument is that it's actually the last vote that you count. It's sort of the straw that breaks the camel's back. And the last vote that's counted, for or against, is the vote that makes the decision
Right.
on the current scheme, correct?
Right.
Do you agree with that?
Yes.
I'm always fascinated by the difference between the integral and the integer, and that's kind of what we're dealing with here. In the case that we're proposing, though, what we're actually doing is shifting that last vote from the 12th vote to the 9th vote.
Right.
I think that's a logical and reasonable conclusion then, that we're still going to be looking at one vote that will change the entire vote.
Right.
Would you agree with that?
Yes. I mean, as I envision, at some point the jurors will have to come in and they'll say we're 9-3, and the judge may inquire. I'm sure the defense will eat too. Are there really 3 or are there 9? I mean, the jurors will have to stand up and say what their vote is. That's the way I envision it. An unanswered question is, what is the jury going to be told in the instructions? Are they going to be told about this 9-3? If they are, then you're not going to have true deliberation. Are they going to say, we want you to reach a unanimous verdict, we'll let you know what happens if you don't later? That's unanswered in this bill. And that's just one more piece of litigation that this bill is going to cause.
Oh, yeah.
Thank you, Mr. Chairman.
Thank you very much. Does anyone else have any questions of this witness?
I have just one.
Go right ahead.
And I just read it. I was doing research like my distinguished colleague, Representative Collins. I noticed in Florida they requested, the Supreme Court requested the legislature to re-examine not requiring a unanimous verdict. Was that one of the cases you cited, Caldwell versus Mississippi, or some other case? Or?
No, Caldwell versus, there was a case called Hickok which involved the Florida system, I think it was. It has to do with whether you could consider matters other than those things that were listed in the statute.
Okay. At present, is the Florida case being appealed to the Supreme Court, or what's the status?
Yeah, there's litigation all over the ballpark in the Florida situation. I think the next person, Chris Adams, can give you a little more expertise in that, but there's federal litigation in the wake of the Ring decision about the whole Florida system, and the Florida Supreme Court itself. Members of that Supreme Court have encouraged the legislature to go to the Georgia system because of these potential problems in the Florida system.
I was just reading something to that effect. Yes. Thank you.
I think the next two people, Mr. Adams.
Yes, Chris Adams and Jerry Ward, are y'all together?
Yes, we are.
Oh, I know.
Is it Ward or Word?
Word.
Word. Sorry.
This was his very soon.
Give us the word, Mr. Word.
I'm going to let Mr. Adams.
Yes.
All right.
I already had to frantically make child care changes.
Okay, so, all right, so Randall, let's see if we can get this done by 5. No, West Thurland.
Okay. Oh, yeah, Chris gave us some good
Jerry, you've lost your quorum. We have a handout that's coming around that outlines some of the issues that we see involved in the question before you. And I'm Chris Adams from the Georgia Capitol Defender Office. This is Jerry Word, who's on loan to our office, but is the public defender for the Coweta Judicial Circuit. The one, I guess, the preliminary question is, do we even have a problem in Georgia? And there's been a lot of talk about the problems with some runaway, or perceived to be runaway jurors. I would contend that we do not have a problem under the current system, and that we're in the top 10 in the nation in number of death verdicts. We're the top 10 in the nation in number of executions that have been carried out. We're currently 6th in that category. We're top 10 in the nation in number of pending death penalty prosecutions in the state. This system in Georgia has not been unduly difficult for the prosecutors to get a death verdict when they choose to go that route. And I guess further, Mr. Chairman, it ought to be a difficult verdict to get. And what we're really talking about from a policy matter is if you change from unanimity, the constitutional issues aside, when you change from unanimity to 9, you're really talking about adjusting the area of risk. And if the reason for the bill is that there are a couple of cases that were 11-1 or 10-2 that rub people the wrong way, when we get down to the 9-3, there are going to be more cases which fall on the other side, that the community cannot and will not get behind and won't have confidence in the outcome. I think that's a cost that's appropriate for this committee to consider. Jack went after us yesterday and stole a lot of our material, so I'll try to skip over some of that. But I would like to point out that there are 2 states that in felony cases don't require unanimous jury verdicts. That's Oregon and Louisiana. And those cases went up to the United States Supreme Court, and they said that you don't have that right under the Due Process Clause in those 2 places. In both of those states, those were constitutional amendments to the state constitution. In Georgia, as Jack indicated, we have a right, a fair trial right, and the jury shall be the judges of the law and the facts. And as I read that, that will be the law and the facts of mitigation. And by coming up with a 9-3 hybrid system, I think that this would unconstitutionally delegate that, and I suggest to the committee that the safer course of action would be to propose this as a constitutional amendment rather than as a statutory change. We cite on the bottom of page 3 the Wright versus Davis case and the Ball versus State case. But unanimous juries, and yesterday I think there was some confusion when we used the term verdict. In a capital case, there truly are 2 verdicts. There's a verdict as to the first phase of the trial, and then there's a sentencing verdict which comes down. And unanimity has been required in Georgia law, and I think the only way to really change that legislatively would be to propose it to the people of the state of Georgia. One, I guess I would like to touch briefly on Ring versus Arizona. And I'd like to point out to the committee that Ring changed the landscape significantly on what appropriate statutes were. The Arizona statute had been approved by the U.S. Supreme Court in 1989. It was reversed by the identical 9 justices in 2002 by a 7-2 vote. And that's significant. This was not a 5-4 case where a couple of liberal justices maybe got away with something. This was 7-2, and the only 2 dissenters are now off the Supreme Court. It's Chief Justice Rehnquist and Justice O'Connor. The other 7 justices agreed. Justice Breyer, in a separate concurrence, talks about the uniqueness of the jury sentencing in capital cases. And I'll point out, because we're really talking about not going to a system identical to Florida or Alabama, but very, very similar. And I'll point out the next to last, or the last page, in the dissent by Justice O'Connor. She said, today's decision by the court is going to add to these already serious effects. And she then talks about some of the other states and said, nonetheless, the need to evaluate these claims will greatly burden the courts in these 5 states she talked about. In addition, I fear that the prisoners on death row in Alabama, Delaware, Florida, and Indiana, which the court identifies as having a hybrid sentencing scheme, in which the jury renders an advisory verdict but the judge makes the ultimate determination may also seize on today's decision and challenge their sentencing. I think not only in footnote 4, but in the dissent by Justice O'Connor, there's a clear indication not that the court's going to ultimately side with the defense, but that this is a gray area, and this is something that is legitimate litigation. And if we sentence a bunch of people to death under this modified statute, and the U.S. Supreme Court with Scalia and the others who really like the unanimous jury verdicts, it's going to be a problem for this state. It's a problem for my office if we have to retry a bunch of closed cases. It's going to be a problem for victims as they have to go back through this, and a problem for DAs as they have to try to reassemble their cases. And I think that's a significant concern that properly should be considered. Across the country, there are 38 death penalty jurisdictions. 34 of them require unanimous jury sentencing. 4 states do not. And they're the 4 we just mentioned, and those are the 4 with the question marks by their statute. Georgia would become the 5th. There was a question in the U.S. Supreme Court about whether Ring applied retroactively, and Summerlin versus Shiro decided last year, and it was determined that did not apply retroactively. The only impact that has to your decision is that means the invigorated new post-Ring challenges to both the Florida and Alabama statutes are not likely to come in the federal courts for several more years. So everybody in those states, each death verdict in those states has an issue in it that ultimately could be reversed on the logic of Ring that's been around since 2010. The one other thing is the proposal in House Bill 185 is not identical to the Florida scheme by any stretch. But I'd like to point out that when we're talking about the allocation of risk and whether we err on the side of improperly sentencing someone to not to be free but to life without parole, who maybe other people think should have gotten death, or to death, Florida leads the nation in exonerations from death threat. They have 22. And I think there's no surprise that you have a correlation between reducing the number of jurors who you need to decide that verdict and how many innocent people get caught up into this. Georgia has had 5 people exonerated from death row, even though we require unity. We all know that that number is likely to go up. I mean, I know I do the best I can do on the defense. I'm certainly not perfect. I know my friends who prosecute cases do the best they can do, and none of us claim to be perfect. We're human and we all make mistakes. The risk of error has got to go up and be exacerbated by reducing what it takes to get a death verdict. The last item I'll touch on is really what Mr. Martin indicated a second ago. We're talking about the disenfranchisement of 3 voices on the jury. And it's not just the votes, but it's the voice. Because if the jurors, once the jurors know, I only need 9. I mean, it's human nature. As y'all sit around the room and count how many people are going to be here when it's time to vote, you know how much you need to listen to some of the others, how much common ground you need to find. If you know early on that you can just discount 3 people who don't agree with you, you're just not inclined to want to work with them, to come up with common mutual understanding. And I think we could call some people to that effect. But I think that's really what's going to happen. We're going to deprive 3 people of their vote, but also of their voice to be heard. And the question Chairman Knox asked a minute ago is we really are talking about the sanctity of unanimity. And it's not a consensus function, and it shouldn't be a consensus function when a human life's on the line. Mr. Word.
And I'll be extremely brief, Mr. Chairman. And Chairman Mumford, you asked the question, what does the word inviolate mean? And I think the Wright versus Davis case answers that it's all the rights enjoyed at common law, which would include unanimous jury verdict. We've set that out in the paper. The only other thing that the representative asked about the Florida case that's in here, that's State versus Steele, where the page 4, where the Florida Supreme Court called on the legislature to require unanimous verdict like Georgia. So we're stepping backwards, actually, if we do this. And I'd ask you not to abandon 30 years of proven death penalty litigation. and 300 or 400 years of jurisprudence and unanimous jury verdict, and this is something that people should vote on. It would require a constitutional amendment with my reading of Article 1, Section 1, Paragraph 11 of the Georgia Constitution.
If I may briefly, yesterday we were asked about the Arizona scheme, because there was a lot of talk about Arizona. We pulled that scheme, and they require a unanimous jury finding now. They do allow for a retrial option if there's not unanimity in the first trial, and that's been something that I know we've talked about as a defense community and prosecutors, and nobody's ever wanted to talk about a retrial in a sentencing case because of what ours still long. It's onerous on everyone. But that would be a clearly constitutional remedy. That is what they do in the federal death penalty scheme. If it's 11-1, if it's 9-3, if it's 6-6, if it's anything other than unanimous, there's a right to have a retrial. And you get, I believe in the federal system, you get 2 retrials. And if there's not unanimity for death by then it becomes a life without parole sentence. That's not my favorite option. I'd rather you do away with the bill altogether. But to get back, another remedy for an aberrant, a runaway juror, is to include, either have the judges do it or to include in the statute some type of jury instruction which requires the jurors to deliberate in good faith, and to be told that, and to define what deliberating in good faith is, and then have that be reported out by the foreperson if that's not done. I think that would do away with the one case in 100 where a juror may not tell the truth in voir dire.
Are y'all finished now?
Yes, sir.
Okay. Questions, Vice Chairman Mumford?
Isn't there already a jury charge in every criminal case that says something to the effect that your demeanor, or I forget how they say it, in going into the jury room is of some importance? I advise you not to take a fixed position. I advise you to listen carefully to consider the opinions of
Be
the fellow
collegial.
jurors.
Yeah, the pattern jury instruction includes basically that you're not partisan, you're to listen to everybody else, and then you ultimately must make up your own mind, but only after listening to the opinions of the other jurors. You're right.
Further questions? Representative Collins.
I want to go back to this, and I understand the argument presented. I appreciate, as I told you, and we shared absolutely your absolute best, and depending whoever may come. I think what I'm going back to, and just in an honest reading, and Scalia's name has been thrown out, especially concerning the Ring decision, and he goes on to say in his dissent, he said, what today's decision says is the jury must find the existence of the fact that an aggravating factor existed. Those states that leave the ultimate life or death decision to a judge may continue to do so by requiring a prior jury finding an aggravated factor in the sentencing phase, or more simply by placing an aggravating factor determination where it logically belongs in the guilt phase. This is the last paragraph of his concurrence. And he's also, at that point, also, to be fair, he's also picking fun at Justice Breyer by his not going along with the Apprendi decision, but now seemingly wanting to go along with Apprendi. My only thought in an honest reading, and there may be honest disagreements as to where the reading goes, to say necessarily that the Supreme Court has given a hat tip or anything else that this may be found unconstitutional. Going back to the footnote 4, which I looked up profit, which had a different scheme again as well, this bill, true or false, does not do anything to the current finding of aggravated circumstances by a jury.
No, if you had one holdout who didn't want to play well with others on the aggravating circumstance, there'd be nothing that this bill does to address that.
So there's still, okay, so that, and according to the scheme here, and even Scalia speaks to here, who goes in concurrence with this opinion, it doesn't affect that in any way.
Correct.
Okay. Then I'm trying to walk your logical argument through that this Ring decision necessarily kind of do it. Is there a possibility of grave, it's not grave concern, but a concern that this may be found? I'll go along that there may be. However, in using it as an implication, I think just an honest reading would tend for both of us to say, there may be a legitimate disagreement here. It doesn't go as far as you want it to say. It may not say as little as I want it to say, but to use it as a definitive argument is not probably the most solid.
Well, I would say that yesterday all the Dean Emanuel was here, the defense lawyers were here, and we all said it's an open question. The only people who said it was a closed, defined question were people speaking in favor of the bill. And and I think you find that on any new law. Prosecutors tend to say everything's constitutional. We say everything's unconstitutional, and sometimes we win, and sometimes, more times than not, they win. But the reality is, according to the court in Ring, these are open questions. And there was a disagreement even among various states when they read Ring on what the proper response should be. And Nevada, Colorado, Idaho, Arizona changed their statutes to be in line with Georgia's now. Alabama, Indiana, Delaware, and Florida have sort of held the line and say they're going to try to defend it a little longer and see where it goes. And so I think it's an open question.
And I understand it's like everything, and I've been made so wonderfully aware in the last couple of years that everything can be an open-ended question with the Supreme Court. It's really, I think we'll all laughingly say it depends on the day and it depends on the 9 in the box.
Well, in all fairness, the current statute's not an open question. That was decided in 1976.
Exactly. I'll go along with that. But from either side, we can throw arguments against the law as it stands. And I think that's the question I'm having. And just wanting for clarification, I think we've at least agreed here that a principle reading either side of Ring, because it does not say specifically maybe what I wanted to say or somebody else wants to say or even what you wanted to say, it's now up to the lawyers to make the argument. Would that be a fair statement?
Well, the lawyers will always make the arguments. I guess it's up to the courts to decide which argument takes the day.
I understand, but unless the lawyer makes the argument before the judges, there's no argument to be made.
I believe that's correct.
Thank you.
Further questions?
I just want to ask if you have it, and I want it if you don't have it. I believe last year, year before last, I saw some very disturbing statistics. If an African American was tried by an all-white male jury, it was like 90-something%. It was definitely going to be found guilty, no matter what the facts. Are you familiar with what I'm referring to?
Yes, sir.
Could I get some of that statistics, or do you have that type of statistics?
I do not have that with me today. I can get that for you.
And basically, if I'm tried I won't prejudice any of my counties in Georgia, but there are some counties that are more Anglo-Saxon than others. And I won't even go that line of question today.
We know what you mean.
But is it not true that in Georgia there are approximately 30% African American or non-Anglo-Saxon? And you basically, when we pass this law, one of the unintended consequences would be that some of those African Americans who are sitting on those juries who say, well, we don't think that this guy should die, be executed. Basically, their vote will be little or nil. Is that correct?
Their vote and their voice. I mean, the rest of the jury won't even have to deal with where they're coming from and how their perspective on the community is different from their own.
They won't have to talk about how it is to grow up in the hood.
Correct.
Thank you.
And one other response, if I may, Mr. Chairman. 82% of the exoneration out of Florida were African American and Latino, and 68 nationwide and 123 were minorities. So I think that says something about the exoneration rate.
Thank you, Representative Mangum. Further questions? Thank you all very much.
82%.
I think now we're going to. Christine Kohler. Is it Kohler?
I need it. Okay.
And I understand you have a trial juror from the Harris case.
I do, Mr. Chairman.
And today I do. And did you have Karen Kilcarney with you?
Karen Kilcarney is right here with me, please.
Okay.
Mr. Chairman, good afternoon. Good afternoon, members of the committee. Thank you. I was here yesterday, and I'll try not to repeat as the day seems to be getting longer and longer in the room, warmer and warmer. But I think that there has been somewhat of a false framing of the issues in this situation. we've gone from there are rogue jurors and they're lying to get on the jury to that's a very teeny tiny percentage, or maybe there are more. I did ask Mr. Kilcarney, who I hadn't spoken to in more than a year after the Wesley Harris verdict, to come and join me today. I am the criminal defense attorney who was appointed by a Superior Court judge to represent Wesley Harris in the case that has received so much discussion here today. And I guess my main concern is that you were asked to watch a video today, and the looks on your faces were very similar to the looks on my jurors' faces when they saw the photographs of Whitney and Jordan Land that were so awful in my case. But I think that it is misleading somewhat to show you a 5-minute video and ask you today to make a judgment about a law that has been in place since, I guess you read back to, before our country even existed. So I have grave concerns that you would see a less than 5-minute video and make a decision about whether you think jurors made the right or wrong decision in that case when one or two of them voted for a decision other than the death penalty. I asked Mr. Kilcarney to come a couple weeks ago. I called him and said, I'd like you to come because it's been reported in the papers that somehow you didn't perform your civic duty when you voted for something other than the death penalty, when you voted for a sentence of life without the possibility of parole. And I'd like you to explain to people why you voted the way you did if they have those questions. And also I'd like you to explain that from the first moment you filled out your questionnaire before you knew anything about this case, you expressed your concerns with the death penalty, which made you a juror that I was interested in seating on my case. And so from the moment Mr. Kilcarney and the other juror who chose not to vote for death in my case filled out their jury questionnaires, which was day one of a 9.5-week trial, they said, I have some concerns about the death penalty. I don't know that I want to be the person to put another person to death. It would have to be a very small circumstance under which I could vote for death. And Mr. Kilcarney in particular expressed that he would only vote for death in a case where the state showed extreme premeditation. Now, he could vote for guilt beyond a reasonable doubt, and he could find aggravating circumstances without any showing of premeditation, because that's what the law says. But the law also says that a juror can vote for a sentence other than death for any reason or no reason at all. So his requirement that the state prove premeditation, substantial premeditation, which he spelled out in his questionnaire, and he came in and said openly during our voir dire process that took more than an hour with Mr. Kilcarney, he was never inconsistent with that. He didn't trick anybody, nobody got bamboozled. He simply stated that only in certain circumstances, small circumstances, would he be willing to impose a sentence of death. I find it interesting that the one juror who I haven't been able to have any contact with, who said that she back in the jury room that she would not vote for death in this case. It's being claimed that she lied to get onto the jury, that she misled, when in fact her jury questionnaire was equally, I guess, impressive to the defense, that she too would only vote for death in a very small percentage of cases. An assistant district attorney who assisted Mr. Porter with that case came up to me after the trial of that case and after we received a non-death verdict, and he said to me that in fact the woman had agreed to deliberate and that she had agreed to participate in all discussions, but that she would not change her decision, her very personal decision, to vote for life without the possibility of parole. I think what's very important that we know is that if someone says, I will never vote for death, or I will always vote for death after a murder case, those people don't get on the jury. We talked about that yesterday, that it's the people in between who say, yeah, I can think of a case where I would vote for death. It may be difficult, it may be few, but I can think of a case where I would vote for death. Or I could think of an intentional murder case, not an accident, not self-defense, where I would in fact vote for something other than death. Those are the folks who make it into the pot of potential jurors. By showing you a 5-minute videotape or a 5-minute DVD and saying clearly that person should have gotten death, that misleads this committee. into believing that absolutely nothing about the defendant is relevant. It's not an excuse. It's not. I cannot make an excuse for the defendant in the Wesley Harris case. I can't get in here and justify to you why something like that should have happened or could have happened. There isn't an excuse available to justify a horrific crime like that. But under the Supreme Court law, lots of other evidence has to be presented. It was my duty to present that evidence on behalf of Wesley Harris, and 2 jurors found either that evidence compelling or something lacking in the state's case when they came to their decision about not voting for death. I'd also like to say that we keep talking about how do we fix these few rogue cases. That's assuming that these cases need to be fixed. That's assuming that we shouldn't value every single person's opinion when it comes to a life and death decision. I've never had to sit in a death penalty case. I've never had to hold another person's life in my hands. And I think until you've done that, it's easy to say, oh, I'd kill that person because they killed a police officer, or I'd vote for that person to die. But we spent 9.5 weeks teaching people that they are the person responsible for that person's life, not the other 11 jurors, not 10 of other jurors, that each individual juror held another person's hand in their lives. And I was glad, and I believe honestly, that all 12 of our jurors, even the ones who voted against me at every turn, even the 10 who voted for death, I believe that they honestly voted their conscience based on their walk in life and what we call their heart of hearts, because that's what's different in a sentencing phase of a death penalty case. You know, Mr. Porter came in earlier today, and I go against him all the time. That's my district attorney in Gwinnett County. And we're proud to have him as a district attorney. He's an incredible advocate for the state, and not just a good administrator, but a very good trial lawyer. But I disagree with him greatly when he says death is not different. It is the most incredible energy you have ever felt when you sit in a room for 9.5. That case took 9.5 weeks to try. There was absolutely nothing the same about the death penalty case. We have an entire unified appeal process, and judges walk us through how a death penalty case should be done at every turn. Judges inquire of the defendant every single day. Sir, are you satisfied with the services your lawyer is rendering today on your behalf? Those things are all different. You don't experience those in regular criminal cases. I asked Mr. Kilcarney to be here today, and I hope that if you have questions that you'll ask them of him. I know that he answered some questions yesterday, but I think it's very important that people understand that you don't lie to get on to a death penalty jury. It's not, I said this yesterday, but it's not like the Michael Jackson jury. Nobody's going to buy your story at the end of the trial. Nobody wants to hear all the dirt that happened behind the scenes. In fact, it's devastating to people financially, and fortunately enough, Mr. Kilcarney is a COO of an engineering firm in Gwinnett County, and he has the flexibility that not only could he serve on that jury, as was his civic duty, but he could be present today to explain or answer any questions that you may have. I want to talk about a term that I heard today that I didn't hear yesterday. I want to talk about cold feet. When we talk about people having cold feet or changing their mind at the last minute, they didn't change their mind at the last minute. They were asked to keep an open mind the entire time and then come to a decision at the end of the day. If you believe that they had cold feet or that they changed their mind, then you believe that certain crimes always warrant the death penalty, and that's exactly what our law says is not true. People don't change their minds. They reach their decisions, or they form their opinions or their minds once they've heard everything. So to use terminology like cold feet, then that's an assumption that some cases always warrant the death penalty, regardless of the background of the defendant or the facts and circumstances regarding the relationship. I ended my bench trial career yesterday by saying that I don't trust judges, and that we shouldn't trust these decisions to judges in the end. But I do just want to pass this out very quickly, and I'll end with this. Alabama, which is a state we keep hearing about, they do allow judges to make these decisions. And so what I'm passing out is the results of that. And these are advertisements for one of the last judicial elections, and the very first thing that comes across is 9 years ago, a vicious thug raped and repeatedly stabbed a pregnant woman leaving her and her unborn child to die, and then they talk about how the Chief Justice didn't care about that and allowed that person to go free, as opposed to this judge followed the law, and this judge did what was right under the law. Horrible consequence, obviously. Obviously, none of us want to see that happen. But this is what you're going to look for if you allow our judges to make these decisions. They are, in fact, going to make the decision for death. And I'm happy to answer any questions, and as is Mr. Kilcarney.
Questions for Ms. Kohler or Mr. Kilcarney? Any questions? Representative Setzler.
And again, I thank Mr. Kilcarney for coming today. I was sensitive to your story about your company sort of struggling with you out for that kind of time, and I think many of us in the General Assembly can relate to that. Could you just tell your story briefly for this full committee? I thought it was an important part of the conversation yesterday.
Sure, I can hate for the repetition, but I think many of you guys were not here. When I came yesterday, I think yesterday it was said a couple of times. Today I haven't heard that I may have either lied to get onto the jury or not told the truth, or at least I have changed my mind. And I just wanted to kind of go through what happened was that when you go for jury trial, the first thing they make you do is a long, about 19-page questionnaire, and there are a couple of questions related to death penalty. One which said, what's your position on death penalty? And I was pretty clear about that. I said, in a rare case of premeditated, heinous murder, death penalty is possible, otherwise not. And there was a second question there, which said, in your opinion, in the United States, do you think death penalty is more frequently applied or less frequently applied? Okay. My answer to that, in my opinion, it was more frequently than required. That probably was kind of where I never tried to hide those views, and I'm saying now, I'm not against death penalty. In rare case of premeditated murder, when somebody plans it for a particular motive and goes and kills somebody with planned way, I have no problem with death penalty. Also, beyond that, we went into the jury interview process where I think I had to answer questions from prosecution and the defense. I elaborated that again and again. I probably went more than this, and I told them it has to be a premeditated, thought-out process in a planned manner. And I made that clear, and I think from the prosecution side, I was asked several questions about my being a CEO of a company. That means you are not afraid to make difficult questions. Is that correct? I said, yes, I make those difficult decisions all the time. And once that happened, when we went into the initial phase of guilt or not guilty phase of project, I had no problem finding him guilty. In the first vote around, all of us found guilty of several charges. It was not just the top 4 which were required capital punishment. We found him, and I thought there was circumstantial evidence there to prove that. But when
Excuse me, repeat that.
So you thought there was circumstantial?
Circumstantial. There was no direct evidence as I felt, but there was circumstantial evidence there, and it was substantial circumstantial evidence. I have no problem convicting somebody on circumstantial if the circumstantial evidence is very strong. So when we went to the penalty phase, that was the time when I always had that, and I had made it clear right from my first questionnaire to the jury that I needed to have some kind of a premeditation, substantial premeditation, some motive to find death penalty, and that was Judge Weingarten had told us that in case of this next phase, there was no right or wrong answer according to me. We had to make a decision that our conscience we are going to live with, and we had to find aggravated circumstances. And even if we find those, there was no obligation on us having to return the death verdict. And as I told you right from the beginning, that I did not find any premeditation here. And I guess premeditation is a subjective thing probably, but in my opinion it was not there. And in the part of deliberation, that's what I asked others to say, that tell me if you can prove it to substantial premeditation, I'm willing to deliberate. They did not want to, they couldn't tell me what the premeditation was. That was my story, sir.
Thank you very much. Vice Chairman Mumford?
I have a question. As a result of your participation in this case, I assume you've received publicity after this case?
My wife wouldn't let me talk to anybody. So I wanted to, but no, she was adamant about it. So no, I did not.
Well, were you aware that jurors were being criticized?
Yeah,
and were you aware that you were one of the jurors that was being criticized?
I know it. That was.
Did the fact that you were criticized in public, do you think that is going to chill your willingness to serve on a jury again if you ever called?
Probably would.
Do you think that having a division of jurors where 9-3, they, the foreman would report back that these 3 jurors aren't right, would that lead to those people feeling that their right to serve on a jury is chilled, in your opinion?
I guess that depends. I'm not 100% sure on that, because as soon as we got out of the jury, I know some jurors leaked my name. So everybody knew within probably about 10 minutes after we got out who were the ones. So I don't think it would make any difference that way, according to me.
Have you had any other problems as a result of your name being leaked?
Well, I guess I was getting phone calls. The TV station, 3 TV stations kept on calling, and
that's bad enough.
Some reporters kept on coming. I live in a gated community. They used to basically nobody would open the gate, so they would wait behind another car and just kind of sneak in. And my son had to. He was in senior at that time, and he had to say no. Finally, my wife went down and told them that no, my husband is not gonna.
Did you receive any threats of any kind?
No, I did not.
Yes or no?
No, I did not.
Interesting. Chairman Knox.
Not really a question, a statement, if I may. And I think I said something similar yesterday, but what I would like to know is that I have the highest respect and regard for someone like you who stands up and has the courage to defend those who would attack you for defending their rights in this country. That's what you were doing. I think it's a travesty, injustice to you, has been attacked by folks who don't know what they're talking about and whose own freedom and liberty depends on people like you that have the courage to stand up for it. Thank you very much.
Appreciate it.
Further questions? Further questions? Thank you very much, Ms. Kohler and Mr. Kilcarney. Thank you for being here.
Mr. Chairman, in the interest of time, I just wanted to go ahead and say that we have Jeff Brickman from DeKalb, Frank Wynn from Douglas, David Dunn from Lookout Mountain, Tim Midson from Middle Georgia, all former DAs here in opposition to this bill. We also have Ann Emanuel from Georgia State University that we heard from yesterday. We also have Pete Donaldson from our association, Albany, Ed Cleary from St. Mary, and Ricky Morris from Henry County, all here. And they just wanted you to know they were here in opposition to the bill, and
I know
their positions have been
I know many of them have been here.
We also have the Greater Atlanta Presbytery that we heard from yesterday, and also the Atlanta Archdiocese, who also are here in opposition to this bill.
Okay, thank you very much.
Is Frank Wynn still here?
Yeah.
Frank, hey, can I hear from Frank Wynn?
What do you want to hear?
I just want
That's
to
a
know
good
what his
question.
view is.
I'm sorry, what?
I just want to hear your view. I mean, when I was district attorney, you were one of the toughest district attorneys in the state, in my opinion. I just want to know what your view is.
I prosecuted 4 death penalty cases through a jury verdict. 3 of them successfully, and 1 of them has been executed. That's my view on the death penalty. But as I said yesterday, my feeling back then is the same as my feeling now. You have to strive for perfection. And I think that this bill just cuts at the core of the jury verdict and what I learned as a teenager in high school and what I believed as a prosecutor. So I'm against the bill, but I'm not an advocate against the death penalty. I believe when I prosecuted death penalty cases, I said to myself, we didn't have discovery at the time.
that I
Didn't have
prosecuted.
equal strikes, didn't have reciprocal discovery, didn't even have similar transactions, did you? You had to try them one at a time, didn't you?
Well, I did, but my belief as a prosecutor was that I should not go after the death penalty unless I couldn't take that file and open it completely. Even though I was under no requirement, all 4 of those cases were a complete open file policy, even though there was no requirement. Bobby Lee Cook taught me what he could do with an open file.
Is that the one you lost?
Well, I didn't lose the case, but yes, I did not get the death penalty in that case. But that was okay. I didn't come here wanting to change the law. I just dealt with it on the other cases, and that's my belief. If that's what you're wanting to know.
Do you think that do you see any problem with this law that it would result in a chilling of people's willingness to serve on a jury if this law is changed to what's being proposed here?
Well, I think anytime you open up a juror to criticism, you can have a chilling effect no matter what the law is, and this would just be another way of potentially opening it up. Of course, I think it's going to happen. I mean, I think it happens under the law now too.
When's the last time I saw you? About 1992.
It's been a long time till this morning.
Thank you very much,
Mr. Chairman.
Representative Mann.
Recently, the judiciary has been subject to politicizing, and as a former DA, do you believe we would, if a judge in a 9-3 case did not go for the death penalty, there would be advertisements by a competitor coming up to say that he's soft on crime and he's a flaming liberal or whatever other politicizing? Would that have an influence on the political process?
Well, I believe that in this case, the one that y'all heard about, had a judge impose the death penalty as a result of a 10-2 verdict, had not imposed the death penalty, I believe Gwinnett County would have an election that brought it up the next time. The last judicial race, Supreme Court race, just turned me off to politics. I had gotten somewhat turned off in the past, but that just, I didn't favor either one of them. I was offended by the attack, and then I was offended by the response. And the attack was similar to what might have happened had the judge in Gwinnett County overridden a 10-2 and granted the death penalty. That was just a perfect example of what happened.
Thank you for your candor. I see fine people that come up to me. I would love to be in politics, but I can't stand. How can you stand it being around the cesspool? And I think that we really need to take a look at the type of people and the environment we're creating here, to have really people that are not for the public good, but for the political expedient, self-promotion. So thank you, sir. Appreciate you.
Thank you, Mr. Wynn. Ms. Michaels, Sandy, get off here. Let me see if I'm sorry.
Your Honor, sorry.
Did you hear him yesterday?
One of those days it might not be bad. Let me go over your list again. Professor Emanuel, we note is here.
Yes.
Did you say Gary Bowman?
Yes, Mr. Bowman's here, sorry.
Okay.
Not to my fellows, I apologize.
David Dunn. Did you mention?
Yes, sir.
Edward Clary.
Yes, sir.
Pete Donaldson.
Yes, sir.
Wendell Phillips, Presbytery of Greater Atlanta. And Mr. Brickman, I know, and Mr. Morris. So we are noting for the record that each of those are here without further speaking. Is that correct?
Yes, sir, in opposition.
I'm sorry?
In opposition.
In opposition, correct. Okay. Okay. Mr. Bowman, you had your hand up and you had signed up.
Are you saying we cannot address this?
No, I'm not saying that. I was trying to verify what that meant. We still have Mr. Mulcahy. Did you still wish to speak?
Well, Mr. Chairman, I'm at the Church Catholic Conference, which is both dioceses, and I was on the list.
Okay.
So, yes, we're happy just to express our opposition.
Okay.
We don't have to speak.
Okay. Okay, Mr. Bowman, did you wish to speak?
No.
Okay. All right, hang on just a moment. All right, that covers all of those who had signed up for today. Vice Chairman Mumford.
I would like to direct this, I guess, to I don't know, any expert that we have here. I did not hear from this professor this year, but I want to know what year in England we went to a 12-person jury verdict for the death penalty. Was it at Runnymede?
I can tell you very quickly that nobody can tell you the answer to that. I did look into it. The 12-person jury is stated as early as the 1700s as being common throughout Europe, but not uniform throughout Europe. And the earliest historical commentators suggest that the concept of 12 may have come from the 12 apostles, also the 12 tribes.
You don't mean it.
But you can't. I do mean that. But you can't nail it. You can't.
So 1700s. That's 1600. Is that what you're saying? Around
Yes.
1600.
Very early on, you're seeing it. But 1700s.
1700s. All right.
Okay. This subcommittee of this committee spent about, Chairman Knox, 5.5 hours on this bill yesterday. Is that generally accurate?
Hour and a half before that, probably 6 hours.
Okay.
Hour and a half before, about 7, 8 hours.
Did you hear from everyone who had signed up wishing to be heard yesterday?
Yes, sir.
And today we have now been on this bill, excluding lunch, since 11:45. We have now heard from all of those who wish to speak, and I think that is important, because regardless of your view on this subject matter, I think this is a very, very serious issue. And I appreciate the respectfulness that each side, with which each side has conducted themselves. Before I look to the committee for further action, Mr. Whip, did you wish to be heard by way of a brief closing?
Yes.
Very brief.
Mr. Chairman, members of the committee, thank you again for the time that you've taken to address this issue, and I think it's worth it because of the importance to it. It's particularly important to the grandmother that came here today asking for justice for her granddaughter, 2-year-old granddaughter that was killed, and her 24-year-old daughter that was killed. It's particularly important for the officer that you saw that was shot in the video when this committee hearing started. Those two people that committed those crimes, and several other cases that we could have told you about that we didn't tell you about today, cry out for you to do something today about the current system that leaves us with the injustice that we received. We can talk all day long about Supreme Courts, by the way, which I don't think Justice Alito and Justice Roberts, the latest two appointments, have made it any more liberal. I think it's going the opposite direction, so if you want some security for what you're about to do, I think you're going to be fine. But we can argue those issues all day long. Now is your time to speak, to say whether or not you think the current system that allows things to happen like you saw today is a right system or it needs to be changed. And I appreciate your patience, and I would ask you to kindly change that with House Bill 185. Thank you.
All right, fine. Okay, just a moment. Any brief questions from the committee to the author of the bill? All right. Any comments from the committee at this time? Vice Chairman Monk.
Mr. Chairman, Majority Whip, members of the committee, ladies and gentlemen, I wish to speak briefly upon this matter. I do not oppose the death penalty, and I have sought the death penalty in a court of law.
The issue before us today is an important one. It is as important as justice, and it is as final as death. My great-great-grandfather was an immigrant to this state from Germany. I believe his English was not so good. His name was Peter Strozier. He is quoted in our family records as having once said that he would let his musket speak for him. He lived through a time in the history of our state when murder, torture, rapine, and arson held high carnival. Neighbor fought against neighbor. Vendetta reigned. What passed for justice was often found at the end of a rope. You will find Peter Strozier's name on the monument to our American patriots who fought at the Battle of Kettle Creek near Washington, Georgia. You will find his remains in a Baptist churchyard in Rail. I don't know why he fought, but I do know what he and his allies created. They created a place unique in the world where the law was not something that came from one man, one king. They created a land unique in the world where the law was king and the people were empowered, and they decided what it was and they enforced it. You can travel all across this state to all of the counties and you will find Greek Revival buildings that contain our courthouses. It is no accident that the civic buildings of this state have architectural elements borrowed from the Greeks and Roman temples to their gods. It is further no accident that across this state there's a little temple, a little courthouse in every district. These buildings were designed as sacred precincts, places for sacred rites, places for sacred deliberations. Courthouses in our state do not exist for county functionaries, lawyers, prosecutors, or even judges, although sometimes they forget that fact. Courthouses exist. Their designs betray their purpose, for within them all there exists the sanctum sanctorum, the high holy place, the sacred ground, the jury room. As you know, I spend many tiresome hours in this committee room, but there is not a day which goes by that I do not look at that portrait on that wall in that corner. I do not know where that portrait came from. I do not know who put it there. I know that many look upon it and only see an old picture of a homely man. It does not occur to them to wonder who that man is or why he watches me so when I enter into this chair in this room. But I know who he is, and I know why he watches me. His name is Thomas Reed's Roots Cobb. He is the man who first wrote this Georgia Code. He had it published, the first published code in the United States, in 1853 in Athens, Georgia. If it was 1856, I apologize. It was the first state code published in the United States. Cobb's father-in-law was our first Chief Justice. Cobb was brilliant and destined for greater things. Alas, he died at Mary's Heights in Fredericksburg, Virginia, at the Battle of Fredericksburg. The books you see below his portrait are his monument, our code. When Cobb wrote that code, our revolution had been over for 60 or so years. In that code were found many rights favorable to the accused in a criminal prosecution. Many of those rights are now gone. Juries were once the judges of the law and the facts. Juries once sentenced, Defendants once had twice as many strikes as the state, a change that I had a hand in. The state had to try one case at a time, no similar transactions. Unsworn statements of defendants were allowed that could not be cross-examined. Rights of defendants to closing argument was granted. I'm sure there are other of these ancient and antiquated rights that have gone, but the list I have made is sufficient for my point. Now some gentlemen, my former colleagues, some my friends, come and seek but one more procedural change. Reasonable minds may differ. It is a trifling thing, so small. They ask me to vote to allow a jury's decision to impose the ultimate penalty to be less than unanimous, less than the 12. This trifling request, this small thing asked, as one proponent said, is because one juror wouldn't give the death penalty to a 17-year-old person. The proponents of this legislation, in my view, and I respect them, need to think more deeply. I am reminded of Dickens' A Christmas Carol, when Scrooge is approached by some Christian gentlemen seeking a charitable contribution for Christmas. And he turns to them and he asks them, are there no prisons? Are there no workhouses? I ask these gentlemen today, are our prisons not overflowing? Are there not 52,000 incarcerated therein? Are we killing an insufficient number, gentlemen? My problem with this proposal is that it's got everything fundamentally wrong with it. Courthouses, the people in them, the lawyers, the judges, even the district attorneys, they are not there as servants of the states or the state or even servants of their clients. They exist to serve the jury. Their political aspirations, their point of view, the mob, public opinion, parties' feelings getting hurt, none of these are important. Juries are protected by our code, by our law, by our tradition in the sacred grove where they must meet to deliberate. They come together without party. They come without preconception. They come without special knowledge. There is no I. There is no individual juror. It is not I the jury. It is we the jury. It is we the jury, unanimous, that gives them the authority to send someone to death. They must all agree. It has been so from ancient days. They meet, they hear, they decide, they disappear, anonymous. Our jury system makes mistakes. Errors happen both ways. But it is better than any other system of justice on this planet. The body of the jury is the master. The servant cannot be allowed to inquire into an individual's juror's motivations or rationale after they are impaneled. I have seen in recent months jurors criticized on TV after they have served their state in their duty as a juror. They've had their decisions questioned. They've been identified to the press. This practice I find to be beyond the pale. It chills people's ability to honestly serve on a jury. It frightens. It intimidates. This proposal purports to know the unknowable. That is, its proponents think that they can see into the hearts and minds and consciences of jurors and determine which of the 12 are worthy and which are not. This proposal, if passed, will forever tear the curtain of the temple. It will make the servants masters of the jury and soon masters of us all. I ask you to join me in voting no on this proposal.
Thank you, Mr. Vice Chairman Mumford. Any other Comments from the committee members? Representative Byrd.
Thank you. Thank you, Representative Mumford. I have listened to a lot of testimony, like many of us in this room today and yesterday, and we have been talking about the number of jurors reaching the death penalty. However, no one has discussed a cold-hearted murderer killing an innocent victim who happens to be in the wrong place at the wrong time. Isn't it true in the majority of death penalty cases there is only one person who is the judge, jury, and executioner of an innocent victim? Would you kindly tell me what voice did the victim have? And what right or justice did a dead victim have? Thank you.
Members of the committee. We have a motion House Bill 185. Chairman Franklin's made a motion that House Bill 185 as written be given a due pass recommendation. Is there a second?
Second.
I have a second, a move in a second, so now we have a motion. Representative Levitas.
Mr. Chairman, I'd like to be recognized for a motion.
You're recognized.
Mr. Chairman, I'll offer a substitute motion, and that motion would be to change at lines 28 the word 9 to the word 11. And I'd like, when appropriate, Mr. Chairman, to be allowed to explain the motion. I'm sorry, page 2 at line 28, change the word 9 to the word 11.
Let's first see if there is a second to your motion. All right, we have a motion, the Levitas motion, Levitas amendment to the motion, I suppose, that we change, it's on page 2.
Yeah, it's actually a substitute motion, Mr. Chairman.
Substitute motion, you're correct. Line 28.
Yes, Mr. Chairman.
Changing 9 to 11.
Yes, Mr. Chairman.
And that has received a second. You're recognized to explain your substitute motion.
Thank you, Mr. Chairman. I will not attempt, because I could not do it, to follow the eloquence of either of the previous two speakers or any of the speakers that we've heard. I, like many other of my committee members, have sat through several days of testimony and heard the impassioned and well-reasoned testimony of many people whose beliefs, I believe, have been come to honestly. However, I would add, in addition to these passionate pleas, another element which may seem somewhat cold-hearted, but I think is still part of the duty of legislators, and that is to safeguard our trust of the citizens as well as their taxpayer dollars. And we heard, though she did not testify today, from a distinguished professor from Georgia State University, whose opinion I certainly respect, and I myself have contacted a former law professor of mine at the University of Georgia who specializes in criminal procedure. And what I do not want to see this committee do, regardless of whether it decides to pass a unanimous or non-unanimous bill ultimately, or whether it gives a due pass or not, is to turn something over to the courts that is not likely to receive the approval of the Georgia Supreme Court or certainly of the United States Supreme Court. And while I think everybody agrees that there is no definitive answer, nobody knows what that answer would be. And while there have been Supreme Court precedents recognizing a non-unanimous verdict in a non-capital case, I don't think the cases go as far either to say that it would be upheld or it wouldn't be upheld. But I do think that the courts have made it clear that the death penalty verdict is unlike any other verdict that a jury will decide upon. And I believe they will apply very strict scrutiny to anything that we do. And I simply do not believe, based on the decisions that I have read, and I asked the prosecutors, which they were kind enough to do, to supply me the opinions upon which they were relying for their belief, this would pass Supreme Court muster, United States Supreme Court muster. I've read them, and while I don't while I concur with their opinion that there is nothing in there that says that that such a scheme would not be upheld, I also believe that it's equally likely that such a plan would not be upheld. I think that we increase the chances of something being found constitutional if we make it close to the existing standard. I think a 9-3 scheme is a wide departure and a significant one, and one that I simply could not support. For those of you who've been at subcommittee, you've heard me testify, you've heard me say from this seat, which I'll repeat again for the benefit of those of you who were not here, that I favor the death penalty. I am not against it. But I do want to see us, if we are going to have a non-unanimous verdict, that we apply the most reasoned decision that we can, that we pass out something that we believe will pass constitutional muster rather than something that is unlikely to. I'm not going to get into the discussion about whether or not the majority of citizens of Georgia favor the death penalty, because I don't believe that ultimately is what a jury is there to decide. But I do think, Mr. Chairman and members of the committee, that we may be putting the cart before the horse. There are problems with witness identification that have been discussed. There are problems with the pattern charge that have been discussed. There are standards for due process consideration that this committee should undertake. If we are going to allow for the imposition of a death penalty, I think we need to apply as high a standard to a non-unanimous verdict as is possible. So I make this motion understanding the seriousness of the action that we take today, and with the hope that my colleagues will join me in recognizing the need to come close as we can to a bill that will pass constitutional muster.
Thank you, Representative Levitas. Any further? Mr. Whip, did you want to be heard on the amendment?
Probably inquire first, Mr. Chairman.
Yeah.
Is a motion in substitute of Mr. Levitas' motion proper?
From a member of the committee, it would be.
So you can have a substitute motion to a substitute motion?
I think that's correct. But we don't have that yet, so if you wish to be heard on the Levitas amendment as the author of the bill and for your 3 years of work on it, I would certainly recognize you.
I recognize that some are talking about the concept of whether or not we should do this or not. To others, we may be talking about whether or not it is correct. In the case that brought this whole issue to light most recently, although there are numerous cases in the world where this problem existed, as well as 10-2 marriage case. I would like to believe there's something that David answered the question that was presented in that case in such a way that the judge could have the decision to apply the death penalty and the follows funds. I drafted the bill at 93 because that's the way I thought was the best number to get super regarded. I would prefer 10-2 rather than 11-1, obviously.
Further discussion, Representative Lunsford.
Chairman, just for clarification, if I could, parliamentary inquiry.
Yes, you're recognized.
We're all together, that I understand it. The last person convicted in the United States and put to death was September 4th, 1964, in Alabama, a guy named James Colburn, for robbery. Since then, it had to be murder to be sentenced to death. And once we have the trial, and you have your jury, you have your capital sentencing, your direct review, your state collateral review, federal habeas corpus, and then in many cases, if they protested under the 1871 Civil Rights Act, they get another review. I think we have the bootstrap protection there, and I'm not sure that the 10-2 or 11-1 is as critical as people think it is with the unanimous verdict, because we have 5 other things that have to occur. And am I incorrect on that, sir, or is that pretty close?
I think we could have general consensus in the room that there are very extensive safeguards post-trial built into capital cases.
Yes, sir. So hopefully if something was blatantly out of whack, then one of those 5 or 6 steps, you would assume that it would stop somewhere along that line.
Well, I think that
It's debatable, I guess.
that's
Isn't it?
debatable. I think we can leave it that there are extensive reviews subsequent to trial.
Thank you, Mr. Chairman.
Further discussion? Is there any further discussion? Chairman Knox.
What happened to the author's suggestion or comment about a 10 to 2? I'm not sure if he was offering a change to his bill, or what's the posture of that?
I think the author understood me to say that a substitute to the substitute motion was proper if it was offered by a member of this committee. And at this point in time, we have the substitute motion by Representative Levitas, which would change 9 to 11 before the committee. Representative Collins, you're recognized.
Substitute to the substitute amendment, Representative Levitas, for him to replace the line on line 28, replace the original 9 and 11 to 10.
You've heard a motion or a move by Representative Collins. You've heard a move by Representative Collins. Vice Chairman Mumford.
We had a motion and a second on the table. Don't we have to vote on that before we go to the next?
No, I think that's going to become moot here rapidly. Okay. There's no second to the Collins motion. So we have the Levitas motion now on the table. I offered a chance. Well, I extended a good bit of time, I think, for that. Chairman Franklin, with all due respect. And then I subsequently recognized Vice Chairman Mumford. I mean, I don't think there was any question but what I was leaving that open for a second. So as much as it pains me to do so, I'm going to rule your second as being tardy.
I'm going to take one, Mr. Chairman.
Good.
In that motion is still on the table. It is also proper for another person now, such as Representative Franklin, to make a substitute motion. Is that correct?
That's correct. Chairman Franklin. You're recognized. Heard a move by Chairman Franklin.
Parliamentary inquiry.
Representative Mangum.
This is really a follow-up on Representative Mumford, because technically it is possible that someone may be for one, the motion that is on the floor, but may be against the motion that is proposed to be a substitute. They are not mutually exclusive. So I would ask that the court, in this case, the chairman, rule on the proper parliamentary procedure, that being that this particular motion is a second non-exclusive motion that would be out of order.
Well, I think that by doing so, I would be putting members in the position of voting against the concept based purely on number. Did we have a second? Okay. I respect your position, Representative Mangum.
Thank you, sir.
All right. We now have a substitute motion by Chairman Franklin. Everybody has heard. Is there any questions about that motion? Any further discussion? Any further discussion? All in favor of, I'm sorry. And that would be page 1, line 5.
Taking account the vote of the jurors under certain circumstances, and striking any jurors in other circumstances. Just leave it open that way.
Mr. Chairman?
Yes,
point of parliamentary inquiry.
Representative Lewis.
Would it not be possible to make a later amendment depending on what the final number is, if in fact the final number is agreed to by the committee, and then make that amendment rather than worry about it right now? Just, in other words, if we vote 10, 11, 12, whatever the number is, and then go back and fix that based on what the final count is on the motion to substitute and the substitute to substitute. I'm happy to amend my motion. I just don't want to stretch it.
How would you amend your motion?
I would just amend my motion to add, replacing on line 5 the word 9 with the word 11. But that would, we'd have to do that for the substitute motions as well.
Okay.
That's why I would.
Actually making the change simpler so that it would fit every circumstance.
Okay. Is there any objection to letting the various motions incorporate the Legislative Council's suggestions? Hearing none, that would be understood without objection. All right, any further discussion? We're about to vote. Any further discussion? Any questions? Question before the committee is the adoption of the Franklin substitute to the substitute motion, which would be a non-unanimous jury of 10 jurors. Vice Chairman Mumford.
I'd like to make a motion to table this, please.
Second.
We have a motion that it be tabled. Any discussion on the motion? Any discussion? All in favor of tabling House Bill 185, please indicate by raising your right hand. All opposed? Same sign. The motion to table has been defeated. Any further discussion on the Franklin motion? Hearing none, all in favor of adopting the Franklin substitute motion, please indicate by raising your right hand. This is the Franklin motion for 10 jurors. All opposed? It failed. The Franklin motion has failed. That brings us back now to the Levitas motion. Any discussion on the Levitas motion? Hearing none, all in favor of the Levitas motion for non-unanimous verdicts of 11, please indicate by raising your right hand. This is for the Levitas motion. All opposed?
Did you want to vote for that?
We have adopted a motion. We have amended House Bill 185 to provide for 11 jurors. That would include the cleanup language in the opening paragraph in the caption. Ms. Travis, is there any further discussion?
Oh.
I recognize the author.
Mr. Chairman, there is one other amendment that I believe is needed to be technical issue. That is on page 3, line 7. It says this act with respect to Article 77 shall apply to all trials which occur on July 1st, 2007. It's been agreement, I believe, that it applies to all crimes which occur on July 1st, 2007.
Okay, thank you. Thank you, Mr. Whip. Just to, if you would hold that just for a moment, Chairman Knox. Jill, is that the way we word that?
For offenses.
Offenses, yeah. Yeah. I didn't think I'd ever seen that. So I wanted to clarify that before I recognized you, Chairman Knox, and I will now.
I would move that motion to change that from trials to offenses.
On page 3, line 7, change the word strike the word trials, insert the word offenses. Was there a second?
Second.
We have a motion. Now, is there any discussion on the Knox motion? First of all, is there any objection? Is there any objection? Hearing none, that amendment is adopted. Further discussion. Representative Levitas?
I'd like to be recognized for a motion.
You're recognized.
This is a motion to amend at page 3, line 8, beginning striking the word July, inserting the word January, striking the number 7, inserting the number 9, so that the line would now read, or after January 1, 2009. I'm sorry, I've misplaced that. That would also be true, but no, that's right. Let me make sure I've got this. There's 2 effective dates here. I'm sorry. I want to, at line 7, I'd like to withdraw that. My motion actually should make that change beginning on line 7. Change July to January, change the 7 to 9, and also make that same change so it's consistent on line 8, so that it would now read, this act shall become effective on January 1, 2009, and shall apply to all trials which occur on or after January 1, 2009.
Well, all offenses.
All offenses, I'm sorry.
Is there a second on that?
Second.
We have a motion that on page 3, the effective date be amended to January 1, 2009, and that have application to offenses which occur on or after January 1, 2009. Representative Levitas.
Mr. Chairman, this really is just to give an opportunity for some of the things that I addressed in my initial motion to be have an opportunity to be considered by the legislature, by the courts, and to be affected. I'm referring specifically to things like the witness ID pilot program that was passed out of this committee that Representative Benfield had sponsored, some of the suggestions from former District Attorney Jeff Brickman through our exchange yesterday regarding pattern charge, and some of the other standards for due process consideration. It would just give us an opportunity to look at some of those issues to make sure that we have done what we can to perfect our system as close as we can. As Vice Chairman Mumford points out, we're never going to get it to the point where we're perfect, because it's a system made up of humans with decisions made by humans. But it would give us an opportunity to look at this issue a little more closely and see if we can't make some good changes. Not the DNA evidence, I'm not talking about that. Witness IDs, pattern charges, and other standards for due process consideration.
Any discussion? I want to recognize the author for his good and hard work for his comment.
Thank you, Mr. Chairman. I would ask members of the committee to support this bill, not to vote for this. I appreciate his thought pattern. What you would do with anything with a motion like that, we can change the system. This bill passes. Those discussions can still take place, but I don't want that. If a murder trial to occur between now, or murder to occur between now and then, and we delay, and then this bill not be effective. I think that's
Chairman Knox.
Can we even make it bill effective that far out? Would that be after the bill term ends? When does his term end?
His term ends in January of 2011, does it not?
I guess I'm just in too big a hurry. But,
I wonder how long it's going to take him to hear that. Thank you for your comment. Any further discussion? Questions? You've heard the Levitas amendment to delay for almost 2 years the effectiveness of this piece of legislation. Any further discussion? Questions? If not, all in favor of the Levitas amendment, please indicate by raising your right hand. All opposed. The Levitas amendment has failed to be adopted. Further questions, further discussion on the bill? Representative Setzler.
Uncharacteristically, I won't take long, Mr. Chairman. I want to say to the author of the bill and members of the committee and to the folks that spoke here these last 2 days. I think the author and the folks that spoke on behalf of the bill made a persuasive case that there are cases that jurors come on board and whatever you want to call it are not acting in good faith. I was persuaded. I've seen facts, I've seen stories, and convinced. I was convinced there are such things as aberrant jurors. I was equally convinced, however, and frankly humbled by the likes of Mr. Kilkenny, who came today and spoke, who didn't fall in line with those others that were on the jury with him, whose view of what capital punishment and what the making the case would require to support in the sentencing phase of a capital case, that which would be convincing to him was different than others. And I think it's important to see, and I would suggest that members of the committee consider that aberrant jurors out of 12, at least, as it would seem to me, would make sense we could have one on a jury. It wouldn't seem that we would have 2 or 3 or 4 on a jury that were truly aberrant jurors who were acting not in good faith after the detailed voir dire process. It would seem that as you go from one aberrant juror to the second person, you go from having an aberrant juror to having a caucus of 2 who sees something in the fact pattern, or who sees something in the mitigating circumstances, or sees something in the facts of the case that would suggest that person ought not get murdered. And I thank Mr. Kilkenny. I thank folks that spoke on both sides of this bill, and I would ask the members of the committee to consider that as they make their final decision.
Thank you, Representative Setzler. Secretary Beard.
Mr. Chairman, I'd like to make a motion that House Bill 185 do pass by substitute as amended.
Is there a second?
Second.
We have a motion that House Bill 185, and as it has been amended, be passed by committee sub. Is there discussion on the motion? Is there discussion? Hearing none. Final action on this bill today. All in favor of the motion, please indicate by raising your right hand. Got it? All opposed? Same sign. House Bill 185 will be forwarded on with a due pass recommendation. Now, before we break, I'm just going to talk about tomorrow.
Okay, sorry, I have to pick up my child.
I understand.
Okay.
This will take about 15 seconds.
Really have to pick up my child.
We are not going to take up any other bills today. This committee's been going since about 11:30 this morning, and the subcommittee was going from about 9:30 before that. We're going to reconvene in the morning at 9:30 in this room for the rest of this agenda. Now, as incentive to get through that calendar, we're not going to meet in the afternoon because we've got appropriation subcommittees going. So we're either going to finish by noon or 12:30 or 1, or we're going to come back real late in the afternoon or Thursday morning. So I'll just share that with the members of the committee for whatever helpfulness that might be. Any other business come before the committee?
Mr. Chairman, is it required that I give
9:30 tomorrow morning. Representative Mangum.
Notice of a minority report on this particular legislation? Or
I'm sorry?
The procedure to file a minority report on this particular legislation.
You have a certain period of time, and I will recognize that you have stated your intention to do one, and we will accommodate you with whatever time you need.
Thank you, sir.
We stand adjourned.
All right.